Hi, this is Professor Favors with American Literature. So we are discussing Booker T. Washington's Up from Slavery. We are getting only two selections from the main text. And also, this is part of the turn of the 20th century in terms of the literary work. And then it is also connected to the growth of modernism. So this is American Literature, Booker T. Washington selections from Up from Slavery. This lecture is subject to fair use. And here's Booker T. Washington, 1856 to 1915. Born a slave in Virginia, Booker T. Washington grew up to become the most influential Black author and activist of the late 19th and early 20th centuries. As discussed in his autobiography, Up from Slavery, Washington spent his early childhood working as a slave on a plantation. After emancipation and while still a boy, he first worked with his stepfather in the coal mines and salt foundries of West Virginia, and then as a houseboy. At the age of 14, Washington left home to attend the Hampton Normal and Agricultural Institute in Virginia, a segregated school for minorities, where he worked as a janitor while learning to be an educator. Washington distinguished himself at the Hampton Institute, ultimately returning after graduation at the invitation of the school's principal to teach there. In 1881, at the age of 25, Washington was hired to build and lead the Tuskegee Normal and Industrial Institute, now today as Tuskegee University, a new school in Alabama whose mission was to train African Americans for agricultural and industrial labor. The school was so poorly funded that Washington and his students famously had to make their own bricks and construct their own school buildings. Through Washington's inspiring leadership and tireless fundraising, Tuskegee grew and prospered. In 1895, Washington gave a 5-minute speech at the Atlanta Cotton State and International Exposition that propelled him to the forefront of American politics and culture. American presidents called on him for advice about race relations, and white business leaders sought him out to coordinate chari- charitable giving to black institutions, earning Washington the moniker the Moses of his race in newspapers of the era. So here's some quick information from the main text. So about selections from Up from Slavery. Two chapters from Washington's biography, Up from Slavery, are included here. In the first chapter, Washington recounts his childhood up until the time of emancipation. In the 14th chapter, he reprints his exposition address and discusses his startlingly positive reception by a largely white audience that up to that point was fearful of America's black population. Unlike contemporaries such as W.E.B. Du Bois, Washington did not criticize the Supreme Court's 1896 ruling in Plessy v. Ferguson that the nation's different races should be treated as separate but equal. Instead, he sought to work within the law's segregationist restrictions. Washington pragmatically wrote his biography to showcase the industry and integrity of all African Americans rather than to demonize his former owners or celebrate his personal accomplishments. As you read Washington's two chapters, consider how Washington uses the form of the slave narrative to give examples not only of the horrors of slavery, but also of harmonious and honorable race relations. So we do have some additions. I have changed the before and end date from 1816 to 1954. And we do have some additions in terms of historical implications. So let's go over the um, the previous ones and then look at or call attention to the new ones. So again, 1816, American Colonization Society proposed to free slaves and send them back to Africa to stop slavery, pre-abolitionist movement. So remember, these are historical implications that affect our reading, and the current reading is um, um, on Washington's experiences prior to the Emancipation Proclamation. So 1819, the Panic of 1819, which was our first peacetime financial crisis, Thomas Jefferson founds the University of Virginia. Then, of course, we have Maine and Missouri becoming states, Florida becoming a territory. The Missouri Compromise of 1820 allowed the state to become a slave state, so that affected race relations, of course. 1826, Thomas Jefferson and John Adams die on the same day. Now we have a new one. 1828, Jim Crow is created. That's the character Jim Crow. Thomas Dartmouth Rice, white actor performing blackface. So that's our new historical implication. And it informs the Jim Crow laws and era. 1829, Andrew Jackson becoming president. So then we have the anti-slavery sentiment where the abolitionist movement begins, Nat Turner's revolt, slavery debates. Of course, 1837, Oberlin College enrolling female students, Florida and Texas becoming states, and then the American Civil War begins. We have Fugitive Slave Act, Congress enacting the first Fugitive Slave Acts for refugee slaves date back to 1643. We also have the Dred Scott decision where slaves and blacks who descended from slaves were not considered American citizens and could not sue. So then let's look at all of the different factors that affected the American Civil War as well as the amendments that derived from it. So we know that the American Civil War is 1861 to 1865, the Emancipation Proclamation, which freed Southern slaves, the Reconstruction era, which began 1863 to 1877, and then 1865 is when President Abraham Lincoln is assassinated. 13th Amendment abolishes slavery in the same year. 14th Amendment grants citizenship and equal protection under the law. 15th Amendment gave black men the right to vote, part of Reconstruction, no racial discrimination in voting. And then the abolitionist movement basically ends here. So then we have from 1865 to 1913, industrial revolution changes, technological improvements, manufacturing, etc. And now we have here Jim Crow laws that enforce racial segregation in the South between the end of Reconstruction and beginning of the Civil Rights Movement in the 1950s. That's why we have the 1954 year here, because it actually ends Jim Crow law. So I thought it was very interesting when I was looking this up. The Separate Car Act, which means equal but separate accommodations, that it was at the same time of the founding of the National American Women's Suffrage Association. It's 1890. And then we have Plessy v. Um, Ferguson decision, which assessed the separate but equal doctrine to determine the constitutionality of racial segregation, and it reviewed the meaning behind the 14th Amendment. And we understand the 14th Amendment is granting citizenship and equal protection under the law. So don't forget, the Spanish American War doesn't necessarily directly apply to this historical implication for the text, but it is something to note that it was 2 years after one decision, separate but equal, we have a war, right, that's going on, and that's 18. And then we had prior to that the American Civil War. So it seems like we can't stay out of wars. In the 1920 19th Amendment, women's right to vote. So they formed the Suffrage Voting Association in 1890, but didn't get the right to vote until 1920. And then black women did not get the right to vote until way much later. And so then Brown v. Board of Education of Topeka, U.S. Supreme Court rules that separate but equal is unconstitutional, whereas here it is constitutional. So keep these ideas in mind. So we need to review some post-Civil War laws, the Emancipation Proclamation of 1863, which actually applied to seceded states only. So let's look at recap and new. So we have something that is kind of bringing forward the previous discussion on historical implications so we can see what's actually new. So again, American Civil War between Union and Confederacy, which are your Southern secessionist states. Emancipation Proclamation, all persons held as slaves within the rebellion states are free. Reconstruction era includes legal, social, political challenges of the abolition of slavery, reintegration of the 11 former Confederate states into the United States, okay, into the Union. Assassination of Lincoln, 13th Amendment abolishing slavery, 14th Amendment granting citizenship, equal protection under the law, 15th Amendment giving black men the right to vote, and then the abolitionist movement technically ends here. As it ends, 7 years later, Jim Crow laws are beginning. Okay, some aspect of it was already beginning, but it's the segregation aspect of it, the codification of the law was starting to begin in 1877. So let's review case law: Plessy v. Ferguson, 1896, and Separate Car Act, 1890. So Plessy v. Ferguson, the origination date is 1892, and it was to challenge the Separate Car Act of 1890. And there is a decision date on this for 1896. So the purpose was to assess the constitutionality of racial segregation, referring to the doctrine separate but equal. So separate quarters but equal in terms of value. So don't forget that there are key laws that um, the court case tends to reference. So that's your 13th Amendment, which abolished slavery, and then your 14th Amendment, which grants equal protection of the laws and citizenship. So Separate Car Act 1890 required that railroads operating in the state provide equal but separate accommodations for white and African American passengers, prohibited passengers from entering accommodations on the basis of race. Law does not apply to interstate travel. So within a particular state, intrastate, uh, the Separate Car Act applies, but it does not apply between states or interstate. So there's a test case using Plessy, and I go over that in the next slide. Citizens Committee to test the constitutionality of the Separate Car Law, which was in 1891 when they formed. All right, so the test case was a group of Creole professionals in New Orleans formed the Citizens Committee to test the constitutionality of the Separate Car Law, hiring Albion Torgy, a Reconstruction era judge and social reformer, as legal counsel. The committee chose a person of mixed race, Homer Plessy, who was 7/8 white, 1/8 African American, to argue that the law could not be consistently applied to the failure of the uh, uh, due to the failure to define white and colored races. Plessy purchased a rail ticket for travel in Louisiana, the state, took a seat in a car designated for white passengers, refused to move to a car for African American passengers, was arrested and charged with violating the Separate Car Act, and argued that the act was unconstitutional, citing the 13th Amendment, which abolishes slavery. U.S. District Court Judge John H. Ferguson dismissed Plessy's argument. Louisiana State Supreme Court affirmed the district court's ruling. The U.S. Supreme Court granted Plessy the right to oral arguments on April 13, 1896. The court rendered a decision in 1896, May. So we're going to look at two types of opinions. One is a majority opinion, and the other is a dissenting opinion. So from Associate Justice Henry Billings Brown. First opinion: Judge Brown rejected Plessy's argument that the act violated the 13th Amendment to the U.S. Constitution, which prohibited slavery. So he's saying that his argument that his rights um, to not be separate and still have equal accommodations is a violation of the 13th Amendment. Judge Brown rejected Plessy's argument that the act violated the 14th Amendment to the U.S. Constitution, which granted full and equal rights of citizenship to African Americans. And then opinion number 3, the 13th Amendment, Brown suggests, did not conflict with the Separate Car Act because the Separate Car Act law does not reestablish slavery or constitute a badge of slavery or servitude. Opinion number 4, Judge cited Supreme Court's rulings in civil rights cases 1883, which outlined that racial discrimination against African Americans in inns, public conveyances, and public places of public amusement does not impose a badge of slavery or involuntary servitude. Instead, it infringes rights protected from state aggression by the 14th Amendment. And then the last opinion, the 14th Amendment does not conflict with the Separate Car Act because the 14th Amendment secures legal equality, not social equality. Keep that in mind. It secures legal equality, not social equality. And so that the accommodations were equal and racial segregation did not imply legal inferiority. So by default, it implies social inferiority. The Separate Car Act preserves public peace and good in order. So essentially, you stay on your side, we stay on our side, and we will have good peace, public peace and good order. So here is uh, um, the dissenting opinion from Associate Justice John Marshall Harlan. So his opinion number 1, the court ignored the obvious purpose of the Separate Car Act, which was to exclude colored people from coaches occupied by or assigned to white persons and not exclude white persons from railroad cars occupied by blacks. So the whole thing, the whole Separate Car Act is really applied to blacks, not to whites. Opinion number 2, it is important to compel colored persons to keep to themselves while traveling in railroad passenger coaches. And then the statute interferes with the personal freedom of citizens, particularly the personal liberty and freedom of movement of both African Americans and whites. So even though he's outlining that the Separate Car Act has a particular purpose to keep whites and blacks segregated, separate, and the rule really applies to blacks primarily. But in his opinion, that this particular Separate Car Act still infringes on the personal freedom of citizens just in general, their personal liberty and their freedom of movement. And he's suggesting that our Constitution is colorblind, or it should be colorblind, and that all citizens are equal before the law. The judgment this day rendered will, in time, prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case, which declared that African Americans were not entitled to rights of citizenship. So his dissenting opinion is essentially, um, I'm not sure that he has a problem with Separate Car Act, just in general. I think he's looking at the ideal that everyone is entitled to personal freedom of citizens. Sometimes you can disagree and have a different opinion, but not necessarily have a problem per se with segregation. But he doesn't necessarily say that either. So let's review Jim Crow laws, segregation of whites and persons of color. And here is your Thomas Dartmouth Rice, born 1808 to 1860. So and your Jim Crow laws are technically begin 1877 and end in the 1950s. Jim Crow laws enforced racial segregation in the South between the end of Reconstruction and the beginning of the Civil Rights Movement. Jim Crow was the name of a minstrel routine performed in the beginning in 1828 by Thomas Dartmouth, Daddy Rice, to imitate African Americans in segregated life. And so his stage persona was actually Jim Crow. It is based upon a particular name, and he wore blackface. So let's look at origins, Jim Crow law origins. prior to the American Civil War, because slaves were perceived as inferior in status, there wasn't a need to establish laws segregating them from white people. Provided slaves recognized their subordinate place, both races could work side by side. Although some form of segregation existed before 1860, there was no uniform pattern to segregation. So did not, some states ignore the law between blacks and whites. Instead, some southern states were not unified in how they would apply segregation because there was no real system of public education prior to the war. So some states were fully integrated until 1877. North Carolina saw former slaves and whites sit next to each other in jury pools. Texas required every train to have one car for people of color. So there was no uniform pattern. Jim Crow law creates a uniform pattern. So in 1877, the Supreme Court ruled in Hall v. Decour that states could not prohibit segregation on common carriers, such as railroads, streetcars, or riverboats. The civil rights cases of 1883 overturned key elements of the Civil Rights Act of 1875, sanctioning the notion of separate but equal without using the term. So now we are moving into this understanding of a uniform pattern to segregation. So here are your solutions to the problems of race relations, and it's basically problems of race relations on the side of white people not wanting to be near be near black people, but that's only because it is a retaliatory move due to the abolition of slavery. So solution number one: Louisville and New Orleans and Texas Railway v. Mississippi required segregation on intrastate carriers, so we're still within the state. From 1887 to 1892, 9 states passed laws requiring separation on streetcars and railroads, required equal accommodations for black passengers, imposed fines and jail terms for railroad employees. 5 states provided criminal fines or imprisonment for passengers sitting in cars where their race was excluded. And then solution number 3, Louisiana Separate Car Act, which promote the comfort of passengers, provide equal but separate accommodations for the white and colored races. However, this law marked a humiliating reversal of fortune for black and mixed race citizens who enjoyed a more tolerant attitude and autonomy from the slave state toward people of color. That's your slave state, the state of Louisiana. From toward people of color, Creoles, who were part of a third class, freed descendants of European fathers and African mothers, who could marry, testify in court against whites, and inherit property from their fathers. So, because of this Separate Car Act to support Jim Crow laws, these people here, Creoles, who initially enjoyed a more tolerant attitude, were now subject to this particular law, Louisiana Separate Car Act, 1890. Southern state legislatures passed Jim Crow laws, and they passed it based upon this idea of any ascertainable or strongly suspected of a person having black ancestry, a person of color. Separation of whites from persons of color in public transportation, schools, parks, cemeteries, theaters, restaurants. This prevents contact between blacks and whites. Jim Crow laws were codified by the decision of the U.S. Supreme Court in Plessy v. Ferguson, separate but equal doctrine. So let's return to the not only the test case, but all of the factors leading up to the creation of the committee. So the Citizens Committee to test the constitutionality of the Separate Car Act question. So they based their case when responding to Jim Crow laws on 2 questions. How did the law or train conductor determine the race of a passenger? And the determination of race was a complex question of both science and law. This issue could not be delegated to a trained individual, a trained official. So there's a case, Louisiana X Rail Abbott v. Hicks. So a train conductor. on the Texas and Pacific Railway was prosecuted for seating a black passenger in a white car that was traveling between two states. So that's your interstate. The case argued that Louisiana law did not apply to interstate travel, or if it did, it was unconstitutional under the Commerce Clause. Louisiana court agreed that regulations under the Separate Car Act did not apply to interstate passengers. The committee used Homer Plessy, a light skinned shoemaker, to test the law. So once this law passed here, referring to interstate, not intrastate, but interstate passengers, then the committee went with Homer Plessy to see if it could test the law based upon his race. So we're using Plessy now to test the separate car law for interstate. So on June 7th, 1892, Homer Plessy purchased a first class ticket to Covington in the Press Street Depot in New Orleans. He boarded the East Louisiana Railroad's number 8 train. The train conductor asked him if he was a colored man, to which Plessy replied yes. The train conductor asked him to move to the colored car, and Plessy refused by saying, I am an American citizen. I have paid for a first class ticket and intend to ride to Covington in the first class car. The train conductor stopped the train and had him arrested and forcibly dragged by a detective and with the help of other passengers. Plessy spent a night in jail and answered charges the next day before a criminal court judge. He was accused of violating the Separate Car Act. Plessy failed in court, and the Supreme Court solidified the establishment of the Jim Crow era, 1896. So let's recap Jim Crow laws timeline. Remember 1828, Thomas Dartmouth Rice creates the minstrel character, Jim Crow, stereotype black characters. He's a white man wearing blackface. 13th Amendment abolishes slavery. The case Hall v. DeCour rules that states cannot prohibit segregation on carriers. So that means segregation still reigns. 1883, the Supreme Court declares the Civil Rights Acts of 1875 unconstitutional, which sanctions separate but equal. The Louisiana Separate Car Act requires equal but separate accommodations. On May 18th, Supreme Court upholds the Separate Car Act in the Plessy v. Ferguson case, solidifying Jim Crow. 1896 to 1950s, Jim Crow laws expand to segregation in schools, businesses, sports, churches, hospitals, all ways of life. 1950, Supreme Court rules in Brown v. Board of Education of Topeka that separate but equal is unconstitutional. So then, now that it is considered unconstitutional, it's ending the Jim Crow era. So Congress from 1964 to 1968 passes particular laws: Civil Rights Act of 64, Voting Rights Act of 1965, Fair Housing Act of 1968, and then you have the Loving v. Virginia 1967. Miscegenation laws are considered unconstitutional. So people who are people can marry interracially. All right, so let's recap historical and literary periods today. Not going to be too long, but there's your American Civil War, of course, your Spanish War, and then Romanticism, Realism, and Naturalism influences on the turn of the 20th century writing. So here's your timeline of the American Civil War, just to kind of jot your memory, because the literary work by Booker T. Washington references the war, references also Emancipation Proclamation. So the North and South were divided over the issue of slavery. The Southern plantation agricultural economy depended on slaves, while the Northern economy depended on manufacturing. By the 1850s, abolitionism was growing in the North, and the southern states believed the government would end slavery. The southern states believed the government did not have the right to end slavery. So even though we can have in one area of the country abolitionism, people pushing for the abolition of slavery, we can have another place, another geography, and demographic of people who still want to keep slavery. Abraham Lincoln is elected President of the United States, winning the 1860 presidential election. Lincoln's election led to 11 states seceding from the Union over the issue of slavery, forming the Confederate States of America. Confederate forces opened fire on Fort Sumter, 1861. By 1862, Lincoln called on the seceded states to rejoin the Union or have their slaves declared free. 1863, Lincoln issued the Emancipation Proclamation. The South was devastated by the war. Union preserved. 13th Amendment to the U.S. Constitution ratified. Reconstruction took place 1865, between 1865 and 1877. These events represent the historical context before selections from up from slavery. So here's the results of the Spanish-American War, which was 1898. Just a brief recap. So Cuba received independence. Spain seceded control of Guam and Puerto Rico to the United States. Spain sold the Philippines to the United States for 20 million. The U.S. Senate ratified the treaty on February 6, 1899. Hawaiian planters and businessmen sought annexation, but President Grover Cleveland rejected the request. On appeal to consider Hawaii as vital to the U.S. economy, serve as a strategic base to protect U.S. interests in Asia, and to prevent other nations from taking over the islands, Hawaii instead became a U.S. territory in 1898. So do keep in mind that these are events. These events represent the historical context before selections from up from slavery, which was published in 1901. Don't forget the differences between romantic writing and realism writing. So one is about the fantastical, the heroic, the other is about real, accurate imitation of life. So even though Booker T. Washington's work is more about the turn of the 20th century, you still have and is leaving off the fiction. So realism writing is accurate imitation of life as it is truth in fiction, removing now into nonfiction. So we understand that this is the historical, this is the heroic, which is fictional writing, and this is also fictional writing, and we're moving out of that. And so even though we understand realism is fictional writing, it's still influenced by the American Civil War, which is a truth in fiction, and that it depicts the human cost of the Civil War, American Civil War. Don't forget naturalism, which rejected romanticism. It rejected realism because of its limitations in terms of subject matter. For the naturalist, the realist did not want to offend the sensibilities of its readers. And so you see, Booker T. Washington is not a naturalist writer. His experiences are non-fictional, but he is revealing some aspects of human life in his writing. And then don't forget that the naturalist is the pessimistic, materialistic determinism, where a benevolent deity or any supernatural form is absent, and idealistic concepts such as justice, liberty, innate goodness, morality are shown as illusions. However, in contrast to Booker T. Washington, I don't know if he's necessarily pushing for justice, but he is pushing for education, and he's not worried so much about trying to gain voting rights as W.E.B. Du Bois is. So then, naturalism is a journalistic perspective with narrative distance on the character's degeneration. This is in contrast to Booker T. Washington, where he's referring to himself. He's telling his own slave narrative. So there is no narrative distance. And then quickly introducing the turn of the 20th century, the rise of the immigrant. Okay, so another northern and southern migration. In the United States, the northern and western migration that followed Reconstruction, which was the period between 1865 and 1877, when the federal government set the conditions by which the states of the former Confederacy would be readmitted to full participation in the national government, caused such rapid growth in northern cities that the municipal governments were strained to the breaking point as they rushed to deliver services to millions of residents in thousands of languages. In the West, waves of migration were rapidly filling in the plains and prairies. This population boom set up a clash of cultures that continues to have repercussions in contemporary politics. In less than 20 years, the United States marked two population milestones: population of New York City exceeding 5 million persons for the first time, and in 1915, the total population of the United States topped 100 million. So this is really northern and western migration. So I said earlier about southern migration. Many immigrants to the United States in this period were fleeing from the collapse of the ancient European monarchies and empires. The dawn of the 20th century witnessed the first significant crisis of American identity since the end of the Civil War, because now we have more of an immigrant community. It witnessed also the rise of the African American literary culture and fascination with the West. All right, so that's the end of the presentation. These are the works, so you can find information about the 20th century, Booker T. Washington selections from slavery, the Britannical entry for Plessy v. Ferguson, Separate Car Act, Jim Crow laws timeline, Emancipation Proclamation, and then entry for causes and effects of the American Civil War. Now, you don't necessarily have to use Britannica, but it's more of an edited. They have a um, editorial um, strict strict editorial policy, so you can find that, or history I think.com, or any of those types of websites. Resources, don't forget realism, naturalism, definition of realism and naturalism, Spanish American War, glossary of literary terms, and then point of view. And that's key, because when we're moving out of romanticism, realism, and naturalism into the turn of the modern century, we're moving from um, fiction type works to now nonfiction type works. All right, so here are some Booker T. Washington resources. You have the Britannica entry, American Educator. You have the Tuskegee University biography, and then a bibliography um, of Booker T. Washington. All right, so this is the end of the presentation. Thank you very much for listening.